In 38 days, 5 major gun law changes take effect that could make your concealed carry illegal if you don't prepare now. I'm talking about January 1st, 2026, just over a month away. These aren't proposals or bills stuck in committee. These are confirmed changes with exact implementation dates. And if you carry concealed or own firearms, at least one of these will directly impact you. We're covering everything from the elimination of the $200 NFA tax stamp to new state-level restrictions that could turn legal gun owners into felons overnight. Some of these changes are already in effect as of November 2025, and most gun owners have no idea. By the end of this video, you'll know exactly what's changing, when it takes effect, which states are impacted, and most importantly, what you need to do right now to stay legal. I'll give you specific deadlines, consequences for non-compliance, and action steps you can take today. I'm breaking this down into 5 changes, starting with the biggest federal change in decades. Let's get into it. Change number 1. On January 1st, 2026, the $200 NFA tax stamp fee is being eliminated. This affects suppressors, short-barreled rifles, also called SBRs, short-barreled shotguns or SBSs, and any other weapons classified as AOWs under the National Firearms Act. Now, before you get too excited, let me be clear, you still need to register these items with the ATF. The registration requirement hasn't changed. What's changing is that you won't pay the $200 fee anymore. This was signed into law in July 2025 as part of a broader firearms reform package. Here's why this matters for concealed carry and home defense. If you've been waiting to buy a suppressor for home defense, because you don't want to go deaf if you have to fire indoors, or if you've wanted an SBR for vehicle carry, you just saved $200. That's a significant financial barrier removed, and we're going to see a lot more gun owners accessing NFA items starting January 1st. But here's the catch, and this is important. If you have a pending Form 4 application right now with the $200 already paid, you're locked in. The ATF is not issuing refunds. If you paid that fee in November or December 2025, that money is gone. So if you're planning to buy an NFA item and you haven't started the paperwork yet, wait until January 1st. Mark your calendar, January 1st, 2026. That's when this takes effect. Now, some dealers are already advertising pre-orders for January 1st purchases. That's fine, but make sure the actual Form 4 submission happens on or after January 1st, not before. Read the fine print on any dealer agreement you sign. Let's talk about what you need to do. If you're planning to buy a suppressor, SBR, or SBS, start researching now. Understand your state laws, because even though the federal fee is eliminated, some states still ban these items entirely. California, New York, New Jersey, Illinois, Massachusetts, Rhode Island, Delaware, Hawaii. Suppressors are still illegal in these states regardless of federal law. Also, understand that the registration process still takes time. Even without the $200 fee, you're looking at ATF processing times of 90 to 180 days for Form 4 approvals. The fee elimination doesn't speed up the approval process. You still need to submit fingerprints, passport photos, and pass a background check. Now let's talk about consequences, because this is where people get into serious trouble. Possessing an unregistered NFA item after January 1st is still a federal felony. We're talking 10 years in federal prison and a $250,000 fine. The fee is gone, but registration is absolutely not optional. The ATF will still prosecute unregistered NFA items aggressively. Bottom line, if you want an NFA item, wait until January 1st to save $200, but do not skip the registration process. The ATF doesn't care that the fee is eliminated. They will still throw you in federal prison for an unregistered suppressor or SBR. That's the federal change. But individual states are making moves too, and some have already taken effect. Change number 2. This one already took effect on November 1st, 2025, just 22 days ago, and most gun owners have no idea. The U.S. Sentencing Commission amended federal sentencing guidelines for firearms offenses. Penalties for straw purchases, lying on Form 4473, and illegal transfers just got significantly harsher. Let me explain what this means. A straw purchase is when you buy a gun for someone else who can't legally own one. Maybe your buddy has a felony conviction, so he gives you cash and asks you to buy a gun for him. That's a straw purchase, and it's a federal felony. Before November 1st, you were looking at up to 5 years in federal prison. Now, under the new guidelines, you're facing up to 10 years. The ATF is actively investigating straw purchases right now. They're cross-referencing Form 4473s with financial records, social media posts, and surveillance footage from gun stores. In 2024, the ATF prosecuted over 300 straw purchase cases. Expect that number to increase in 2025 and 2026 because the penalties are now severe enough that prosecutors are prioritizing these cases. Here's another way people get into trouble: lying on Form 4473. Question 21E asks if you're an unlawful user of marijuana or any controlled substance. Even if marijuana is legal in your state, it's still federally illegal. If you use marijuana and you check no on that form, you just committed a federal felony. Under the new sentencing guidelines, that's up to 5 years in federal prison, increased from 2 years. The ATF is also cross-referencing Form 4473s with medical marijuana registries in states where that data is accessible. They're looking at DUI records, drug possession charges, and even social media posts showing drug use. If you post a photo on Instagram smoking weed and then buy a gun 2 weeks later, the ATF can use that as evidence that you lied on Form 4473. So what do you need to do? First, never buy a gun for someone else, even if they give you money. Even if it's your brother, your best friend, or your spouse. If that person can't pass a background check, you cannot legally buy a gun for them. Period. Second, answer Form 4473 truthfully. Every single question. The ATF has databases, and they will catch you. If you're giving a firearm to a family member, understand the legal requirements. In most states, you can give a gun to an immediate family member without going through an FFL, but that person must be legally allowed to own firearms. If they're a prohibited person, felon, domestic violence conviction, drug user, you cannot gift them a gun. That's still an illegal transfer under federal law. Bottom line, the ATF is cracking down hard on straw purchases and false statements. The new sentencing guidelines mean longer prison time, and prosecutors are taking these cases seriously. Don't risk 10 years in federal prison because you thought you were helping a friend. That's federal enforcement getting tougher. Now let's talk about a state making major changes to background checks. Change number 3. Colorado's new Firearms Safety Training Requirement takes effect on August 1st, 2026. This is part of Senate Bill 3, which was signed into law in April 2025. Starting August 1st, anyone purchasing a semi-automatic firearm in Colorado must complete a state-approved safety training course and obtain a permit before they can take possession of the gun. Now, this doesn't ban any specific firearms. You can still buy AR-15s, semi-automatic pistols, and semi-automatic shotguns, but you cannot take possession of them without completing the training and getting the permit first. The training course must be at least 4 hours long and cover safe handling, storage, Colorado gun laws, and a live fire qualification. Here's why this matters for concealed carry. If you already have a Colorado concealed carry permit, you're exempt from this requirement. Your CCW permit satisfies the training requirement. But if you don't have a CCW permit and you want to buy a semi-automatic firearm after August 1st, you need to complete this training first. The training costs between $75 and $150 depending on the provider. Now, if you're moving to Colorado or you're planning to buy a semi-automatic firearm, here's what you need to know. The law grandfathers existing owners. If you already own semi-automatic firearms in Colorado before August 1st, 2026, you're not required to get the permit retroactively. But if you want to buy a new semi-automatic firearm after August 1st, you must complete the training. And here's the critical part. The permit is valid for 5 years. After 5 years, you need to renew it by taking a refresher course. So this isn't a one-time thing. It's an ongoing requirement. The training must be conducted by a state-approved instructor. Colorado is currently certifying instructors, and the list will be available on the Colorado Bureau of Investigation website by June 1st, 2026. Make sure you're taking the course from an approved instructor, because if you're not, that training won't count and you'll have to do it again. Let's talk about what you need to do if you live in Colorado. If you already have a concealed carry permit, you're good. You don't need to do anything. If you don't have a CCW permit and you're planning to buy a semi-automatic firearm after August 1st, start looking for approved training courses now. These courses will fill up fast as the deadline approaches, especially in July 2026. Now, the legal consequences. If you take possession of a semi-automatic firearm without completing the training and obtaining the permit after August 1st, that's a Class 2 misdemeanor. You're looking at up to 120 days in jail and a $750 fine. The gun dealer who transfers the firearm to you without verifying your permit faces the same penalty. So dealers are going to be very strict about checking for this permit starting August 1st. Colorado isn't done with gun restrictions. They're also implementing something even more controversial. Change number 4. Kentucky is implementing an extreme risk protection order law, commonly called a red flag law, on February 1, 2026. This was passed by the Kentucky legislature in March 2025 and signed by the governor in April. Kentucky becomes the 22nd state to enact a red flag law, and it's one of the most expansive versions we've seen. Here's how it works. Family members, household members, and law enforcement can petition a court to issue an extreme risk protection order against someone they believe poses a danger to themselves or others. If the court grants the order, that person must surrender all firearms within 24 hours. Their concealed carry permit is immediately suspended, and this can happen before you even get a hearing. Let me be very clear about who can file an ERPO against you in Kentucky. We're talking about current or former spouses, anyone you've lived with in the past year, family members by blood or marriage, anyone you've dated in the past year, and any law enforcement officer. That's a broad list. And the standard of proof for an emergency ERPO is reasonable cause to believe, which is a very low bar. Here's why this matters for concealed carry. If someone files an ERPO against you, your concealed carry permit can be suspended immediately, within hours, even before you know an order has been filed. You don't get advance notice. The first time you find out might be when law enforcement shows up at your door demanding you surrender your firearms. You have 24 hours to comply. Now, you do get due process, eventually. Within 14 days of the emergency order, you're entitled to a full hearing where you can present evidence and testimony. But during those 14 days, you have no firearms and no concealed carry rights. And if the court makes the order permanent at that hearing, it can last up to 1 year. After 1 year, it can be renewed if the petitioner files again. So what do you need to do if you live in Kentucky? First, understand who can file an ERPO against you. If you're going through a divorce, a custody dispute, or you've had conflicts with family members, document everything. Keep records of communications, witnesses to interactions, anything that could refute false claims. Because once an ERPO is filed, you're on defense. Second, if an ERPO is filed against you, hire an attorney immediately. Do not try to represent yourself at the hearing. This is not like fighting a speeding ticket. This is about your Second Amendment rights and your ability to possess firearms. You need a lawyer who specializes in firearms law or civil rights law. And you need one fast, because that 14-day hearing is coming whether you're ready or not. The legal consequences for violating an ERPO are severe. If you possess a firearm while an ERPO is in effect, that's a Class D felony in Kentucky. You're looking at 1 to 5 years in prison. Even after the order expires, you must petition the court to get your firearms back. They don't automatically return them. Kentucky isn't alone in restricting gun rights, but there's one federal proposal that could override all of this. Change number 5. The Constitutional Concealed Carry Reciprocity Act, also known as H.R. 38, was reintroduced in the House of Representatives in January 2025. If this passes, and there's a real chance it could in 2026, it would force all 50 states to recognize concealed carry permits from any other state. This would be the biggest change to concealed carry laws in American history. Here's how it would work. Right now, concealed carry reciprocity is a patchwork. Texas recognizes permits from 42 states. Florida recognizes 38 states. But California recognizes 0 out-of-state permits. New York recognizes almost none. New Jersey recognizes none. So if you have a Texas concealed carry permit and you drive through New Jersey with your gun, you're committing a felony. If H.R. 38 passes, your concealed carry permit works everywhere, just like your driver's license. Your Texas permit would be valid in California. Your Florida permit would be valid in New York. Your Arizona permit would be valid in New Jersey. States could not impose additional requirements on out-of-state permit holders. They would have to recognize your permit, period. Now, here's the current status. H.R. 38 passed the House in 2017, but died in the Senate. It was reintroduced in 2025 with 213 co-sponsors in the House. That's nearly half the House supporting it. It's currently in the House Judiciary Committee. If it gets out of committee and passes the House again, it goes to the Senate. The Senate is the big question mark. Why this matters for you. If you travel across state lines with a concealed firearm, this could be life-changing. Right now, you need to check reciprocity agreements every time you cross a state border. You might need multiple non-resident permits to cover your travel routes. If H.R. 38 passes, you need one permit, your home state permit, and you're legal everywhere. But here's the critical warning. Do not assume this is law yet. It's still in committee. It hasn't been voted on. Even if it passes the House, it could die in the Senate. And even if it becomes law, some states will likely challenge it in court, creating confusion about enforcement. So until you see this signed into law by the president and surviving court challenges, continue following current reciprocity agreements. What you should do: check the status of HR 38 regularly. If you travel interstate frequently, consider getting non-resident permits from states with broad reciprocity. Florida, Utah, and Arizona are the big three. And always check reciprocity maps before you cross state lines with a firearm. So those are the 5 major changes coming in 2026. Now let me give you your action plan. Here's what you need to do today. First, mark these dates on your calendar. January 1st, 2026 for NFA Tax Stamp Elimination. February 1st, 2026 for Kentucky's Red Flag Law. August 1st, 2026 for Colorado's Training Requirement. And remember, the federal sentencing guidelines already took effect November 1st, 2025. Second, check if your state is affected by any of these changes. If you live in Colorado, Kentucky, or you're planning to travel through these states, you need to understand these new laws. Third, if you're planning to buy an NFA item, wait until January 1st to save $200. And fourth, never, ever lie on Form 4473 or make a straw purchase. The penalties just got much harsher. Gun laws are changing faster than ever, and staying legal means staying informed. That's why you need to subscribe to Guns Law Guide. Hit that subscribe button and turn on notifications, because I'm covering every major gun law change as it happens. Next week, I'm breaking down the ATF's latest pistol brace rule and why gun owners are furious about it. Stay safe, stay legal, and I'll see you in the next video.